Okay, please give us a brief introduction.
I'm Chetan Latha. I'm a resident of Barikada Mayurganj. I have completed my graduation in BA LLB honors from Hidayatullah National Law University, Raipur, Chhattisgarh. And this is my second attempt.
Okay, tell us something about your hobbies, your interests, your achievements.
So my hobby is watching some investigation crime drama series, and my interest lies in basically in sports, especially in cricket and badminton. And I have represented my college team in cricket. So these are my interests.
Okay.
Um, so my question to you is this is your second attempt, you told. So why do you want to crack judiciary exam? What is the reason for being a OJS, appearing the OJS exam?
Ma'am, I think that OJS is a respectable job. Basically, I always wanted to do something for the state, and and I wa- and I wanted to join judiciary because because since since it is I always wanted to stay in my home state, to be honest, and judiciary gives me a bit of stability in my life, and it is a respectable job. Um, so this is why.
Like there are certain other options. Means after doing law, you can join any multinational company firms, or you can do good in academics also. Okay, there are a lot of prospects related to law. So my question is like, can you explain me why being a judge is more important than these jobs?
Ma'am, I had many internships in corporate sectors, but that didn't give me a feeling that I wanted to join those corporate firms. Uh, but when I started studying and preparing for judiciary, then I wanted that this is something I want to do, and also stay close to my family. Um, this is
And
why I want.
God forbid, for any reason you are not able to crack this time, what are the future plans?
Um, Ma'am, then I will be joining some corporate firms.
Okay.
Okay. So, have you been employed anywhere earlier? Like you have some work experience?
No, sir.
No. Okay. And you completed your last law degree. You have done your post graduation LLM?
No, sir.
LLB you have done. Okay. Which year you passed your LLB?
Sir, 2020.
2020. So, like last 2 years, what have you been doing?
Sir, I have been preparing for OJS exam.
Judicial service. And you are interested only for, as you said, only for Odisha Judicial Service. You are
Yes, sir.
not appearing for example, let's say West Bengal or Uttar Pradesh,
No,
Delhi Judicial Service. No, only
no, sir.
Odisha Judicial Service.
Only OJS.
Okay. Um, your honors was in which paper uh, in your uh, uh, in your graduation?
Sir, criminal law and constitutional law.
Criminal and constitutional law. Okay, let us start with that then. Today, basically, we'll focus mainly on procedural law. Okay, and some recent developments. So, under the Indian criminal law, can you tell me who all have the power to arrest? Okay, you can take some time to think about it. Police and all. Apart from them, okay, or even including them, who all have the power to arrest?
Sir, according to Section 41 of the CRPC, police officers have power to arrest a person for the cognizable offences. Apart from the police officers, private people can also arrest persons and take them to the police officers as soon as possible. Armed personals can also arrest people who are committing crime in front of them. Sir, civilians can also arrest according to Section 42 of the CRPC.
Okay. So recently, Government of India has brought three major amendment bills, okay, which will completely or fundamentally change your two of the procedural laws and the IPC. So in short, tell me what are the provisions that the government wants to change, and what is your opinion? You support those, or you have some apprehensions, and give the pros and cons of this.
Sir, I have a little bit of knowledge about this particular thing. And so the three bills which have been introduced are the CRPC, the Indian Evidence Act, and the IPC. Sir, sir, basically, the major change that they have brought is the change in the sedition law. Uh, they are thinking that to abolish the sedition law. Um, but they also want suggestions from different sectors, from the opposition parties also. So the previous laws are very old, and according to my opinion, there was a need of some changes in the provisions. So according to the changing scenarios in the society, they are introducing these laws, and I think it may be a right decision to change to make some amendments in the present laws.
Okay.
Now, what my question is, what do you think were the backlogs in the judiciary system of Odisha? Then, how to means change that? Do you have any suggestions?
Yes, ma'am. Ma'am, the pendency of cases is a big problem not only in Odisha but also in other courts in India. Ma'am, very recently there has been introduction of paperless courts in every district courts in Odisha. This is a commendable step, and it will definitely help the litigants as well as the witnesses and other parties to if they cannot come to the court, they can file suit or present in the online mode. So paperless courts and digital courts are something I think that it will work in the betterment. And
Okay. Okay. Fine. So, Madam asked you, like you said about use of information technology or digital, advances in judiciary. So, can you give us two, three examples of how that has helped?
so very recently, after the COVID period, um, the litigants and the lawyers were facing very too many problems um, uh, in coming to the court. So they have introduced e-courts where they can file suits or and they can present their case in the courts and high courts, as well as in the Supreme Court in the online mode. So this is one thing. And
Okay, this is one thing. Then anything else?
sir,
Okay, fine.
nowadays FIRs are also being registered in online mode.
Okay, okay, fine. Uh, can you tell us? Let us go to the procedural laws, CPC. Okay, can you tell us what do you mean by set off? How many types of set off are there? And explain it to me in very general terms. Okay, suppose I'm a layman, I don't know anything about law. You explain me in such a way that I will be able to understand what is set off, what are the types of set off.
Sir, set off is given under order order 8 of order 8 and rule 6 of the CPC. Set off. There are two kinds of set off: legal set off and equitable set off. So when a petitioner goes to the court and claims, let's say, some money, then the defendant can say that you also owe me some money, which you can just subtract or minus from your claim. That so that is a legal set off. Um, and equitable set off, there is no ascertained sum of money, whereas in legal set off there is an ascertained sum of money. And in legal set off, it must come from the same transaction, but in equitable set off, it does not need to be in the same transaction. So, sir, when one party claims some money, um, then the other party can say that you also owe me some money, so that we can just subtract it and settle it down. Whatever is the remaining amount, I will give it to you, and this is
Okay. You have heard the legal maxim "odi autem patem," right? So first tell me what is the meaning of that and how it is applicable in CPC.
so the maxim audio alterum partem means, uh, let the other party be also be heard, let the both parties be heard. A court or a judge cannot give a decision without hearing the other party. Um, so when a petitioner files a suit, summons are being sent to the other party to come to the court and defend himself or give his arguments regarding the claims or the cause of action. So without hearing, a judge cannot decide a case. But when the other party is not coming to the court, again and again, summons are being sent, or the officer is sent um, to proclaim or issue a proclamation. If he is not coming to the court, then an ex parte decree can be given to the petitioner. So ex parte decree can be given if the other party is not coming to the court.
Okay. Anyway, let us go to you know about the concept of anticipatory bail. So what are the conditions or what are the situations, okay, in which the court will not give anticipatory bail, and what are the conditions in which the court will consider giving anticipatory bail?
So section 438 of the CRPC talks about anticipatory bail. Um, so when so when a person apprehends that a police is going to arrest him for a cognizable offense, he can go to the court or the high court to give him an anticipatory bail. Um, for the death sentences or for life imprisonment cases. Except these two cases, an anticipatory bail can be given to the person. But in these two cases, anticipatory bail cannot be given. Or if the court and after giving anticipatory bail, the court also secures a bond from that person that he will not leave the territory or he will not go outside India. So these are the conditions where anticipatory bail can be given.
Okay. Uh, can a police officer issue a warrant? And if yes, then in what cases?
Sorry, sir, I don't have any idea. Sir, I am unable to recall it right now.
Okay. Is it possible or not? First, tell me that. Then we
Yes,
can
sir,
go to the provision.
yes, sir,
It
it
is
is possible.
possible. Okay. You have heard about judicial custody and police custody. Okay.
Yes, sir.
So, can you tell me what is the difference between the two? Suppose Mr. A, okay, he commits something, he's arrested, and court sends him to judicial custody, and sends Mr. B to police custody. So, what will be the differences between the, in the rights and liabilities of these two people? One is in police custody, one is in judicial custody. So, just differentiate that for us.
So when investigation is going on, it is upon the discretion of the judicial officer to send a person to either to the police custody or judicial custody. Um, when a person is sent to a police custody, it is presumed that in judicial custody a person is on a safer side than in police custody, because in police custody there might be some tortures and some physical harm to the person, which cannot come out in public. But in judicial custody, they are on a safer side. Um, a police
Okay.
custody should should not exceed 15 days. Uh, After that, judicial custody should be given after 15 days.
Mm-hmm. Okay, fine. So uh, recently, the criminality of Section 377 of IPC was, declared to be unconstitutional and taken down by the Supreme Court. What is your opinion? You support that, or you think that no, the old British law was fine, criminalizing, what has been defined as unnatural sex?
So, in the case of Navtej Singh Johar versus Union of India, Section 377 was held as unconstitutional. Um, Sir, in my opinion, I support this decision because Section 377 was coming from a colonial area, colonial times, and nowadays, since there is a right to life and liberty and right to live any person uh, with any person, be it any gender. So I think it's a right decision. So very recently, LGBTQ rights were in in news. So whether they can be given the marriage rights, whether they can marry each other. So the Supreme Court has held that they cannot marry each other, but they have some rights which are given to married couple. So I support Section 377 abolition.
Okay. So in that sense, do you also support, excuse me, same-sex marriages? Like in many European countries, the LGBTQIA community has got same-sex marriage rights. So that is a demand now. Okay, and Supreme Court has also said that the central government should, Parliament should look at it. What is your opinion? Should we allow same-sex marriages in India as a student of law, given our social conditions here? Hmm. So whatever you support or you oppose, you give me at least three reasons for that.
Sir, um, looking at the social conditions in India, um, and according to various smritis and various Vedas and our dominant religion coming from such ancient times, socially, I don't think same-sex marriage is right in India because according to Hindu law, we think it is considered that it is a sacred ceremony between a man and a woman, and not the same sex. So first reason is that socially, I don't think it's a right decision. It's a right thing to get married to the same gender. And in my opinion, I support this right being not given to them. Uh, what what we can do in India is we can give them certain rights as to adoption of children or any other right which is legally recognized for them, except getting married. They can live together and they can have certain rights. They can have joint properties. They can have joint accounts, or they can adopt children, but they cannot marry each other. So I support.
So, like in today's time, lot of media and social medias and electronic media are playing a major role while a case is being taken into a court. So, do you think, as a judge, whether it has certain implications or it will affect your judgment, and if it does not, how will you handle such pressure?
Ma'am, being a law student and studying law for so many years, um, and looking at the current scenario, I know that media trial are being held in majority of the channels. They are they are accusing any person for which trial has not even started yet. So, according to my opinion, it is wrong. But a layman who has not read about the law, or they do not know how a trial is being held, they definitely have a negative impact on that person. So, so, ma'am, according to Audi Altrum Partem principle and natural justice principle, I don't think without hearing the other party, there will be any thought on my mind that yes, he has committed the crime, or there will be any negative impact on my mind. I will definitely hear them, hear their arguments, and take evidences. Based upon the evidences only, I will decide the case, and I will not decide based upon what the media is saying, or whatever emotional whatever is going in the society. I will take the evidences, and only after that I will conclude the case.
Okay, now we say that sometimes the evidences which you told is circumstantial. Okay, so if such a case arises, how could you ensure that you will give a fair verdict?
Ma'am, um, not on, I will not give the judgment based upon only upon the circumstantial evidences. I will take other evidences too. If the evidences or the witnesses are trustworthy, and and the guilt of the accused is being proved beyond reasonable doubt, then only I will then only I will give punishment to him.
Okay. Do you think that local languages should be incorporated in the judiciary system of the states? Like in Odisha, we have a diversified different Odia languages being also diversified. So do you think that court should use the local languages? It will be benefited.
Yes, ma'am. I think it is going to benefit, ma'am. Lawyers and others who have read law, they know English, but the witnesses or the other people who are coming from the village area, um, so they do not know English. Majority of them knows Odia or their uh, caste or that language, Santali, etc. So majority of them do not know even Odia. So I think Odia language should be introduced in courts and lower levels. It should be introduced. It will be beneficial for the witnesses and other people from the villages.
Okay.
Okay, fine. So let us go to some other questions related to law. So under the Indian Evidence Act, um, can you tell me, does the character, previous character of a witness play any role, and what are the exceptions to it? You can, tell us that, both in civil cases and criminal cases. Suppose the defense is able to breach, okay, the character of the witness, in the sense that they are able to prove that the person is, the integrity of the person is questionable. Is it going to have any effect on the quality or admissibility of the evidence that he's going to give?
Sir, I will divide my answer in civil cases and criminal cases. Sir, in civil cases, character evidence is not going to prove any guilt or any innocence of the accused. In civil cases, it is not going to affect it. But according to Section 55, if if the damages, if the quantum of damages is in question, then it is going to have some effect. In criminal cases, negative character is not going to prove the guilt of the accused, but a person can give evidence of the positive character or the good character. Sir, exceptions lies where a person is giving evidence of his good character, then the other party can give evidence of his bad character. And if the previous conviction of the accused or the other party is in question, then the other party can give evidence that he has been convicted previously for the same offense or the other offense. So these are the exceptions which lies in criminal cases.
Okay, fine. Fine. So that will be the end of the interview. Now, I'll give you the feedback. So my feedback is your eye contact, because it's a online interview. I was not able to, considering the camera as the eye of the interviewer, it was around 80 to 90%. Okay, that has to be 100% because there was eye rolling. So when you are practicing with the mirror, keep this in mind that your eye contact has to be 100%. Then um, one answer you did answer in points, that firstly. Secondly, okay, so when you are asked opinion based questions, it is better to answer in points. Okay, otherwise your balance, flow of speech, everything is fine. One more thing we can add is that you try to maintain a smile. Okay, balanced smile, even when you're saying that I do not know or I am unable to recall. Okay, that smile must be maintained, right? So out of 100, I'll be giving you 65 for today's interview. Now, assessment of madam.
I also agree that eye contact should be maintained. And one more thing is that the sentence completion should be perfect. Okay, like we are like it appears that you are going to say something where you have already completed it. Okay, so that should be done. And others, the like your confidence, everything, content, very good. So just work on these 2 points. I think you can get through the interview. I have given you 70 out of 100. Okay.
Okay. Thank you, ma'am.
Thank you.
Thank you, sir.
Okay, thank you very much.
Namaskar.
Namaskar.